Our presenter will be doing a PowerPoint presentation. She'll be sharing her screen with everyone. We just ask that you let her go through the presentation while everyone remains muted with their microphones. If you have any questions, you can type them into the chat. And at the end, once everything's finished, we're going to open it up and she'll be glad to take questions from everybody. So that's the way we hope to work this, and I hope that works well for everybody. That being said, I'd like to thank you for joining us this evening on our Zoom program. And I have the pleasure of introducing our guest speaker, Zahava Schechter, Esquire. And as an attorney and practicing law for more than 30 years, Zahava has counseled and represented hundreds of clients in numerous areas of legal practice, including estate planning, administration and litigation, real estate law, and contracts and business law. We're fortunate she's with us this evening to share her knowledge with us, and please join me in giving her a warm welcome. Zahava.
Thank you so much, Michael. And I want to thank the Glen Cove Library for inviting me to speak tonight. Thank you all for coming out. I hope you will find this an informative and perhaps interesting discussion. And I'm very happy to take your questions after the presentation. I'm just going to give a disclaimer at this point. I'm not going to give specific legal advice to any fact pattern, but if you have general questions, I'm definitely happy to answer them. And you can always contact me afterwards. You'll see my contact information on my PowerPoint presentation, which we're going to start right now. Hopefully everyone can see it. I just want to start the slideshow. And here we go. Hopefully everyone can see. So this is my contact information. Feel free to contact me afterwards if you would like, and I'll have this slide at the end as well. And again, if you have a question, feel free to put it in the chat box or contact me later. So who am I? As Michael kindly introduced me, I'm an attorney with more than 30 years of experience. My primary areas of concentration are real estate, estate planning and administration, which is the focus of our discussion tonight, and business law. I also host a podcast called the LI Law Podcast, all things Long Island that have to do with law. So if you like to listen to podcasts on Apple or on iTunes or Google or however, Stitcher, however you get your podcasts, you might enjoy those podcasts. So the first thing I want to say before we even start talking about estate planning is that over the last, I would say, month, I have found for many clients money sitting with New York State's Office of Unclaimed Funds. If you are not familiar with this website, this is a legitimate website from New York State. They hold money that financial institutions don't know what to do with. So for example, let's say you've moved and you had an account, I'll pick Chase Bank, and Chase didn't know your new address. If it can't contact you and you haven't done anything with that account in a while, a number of years, Chase will turn that money over to New York State. If you do not claim that money within, it's usually 3 years, but sometimes it's longer, New York State actually keeps that money. That's called escheat, E-S-C-H-E-A-T. New York State will keep that money. Right now, New York State, as it says there, is probably holding more than $16.5 billion at this point. And so much money is returned every day. So if you have not ever looked at this website, or if you haven't looked recently, go look at it, the Office of Unclaimed Funds, and hopefully you'll find some money for you and for your family and friends. Tonight, our discussion is about estate planning. Obviously, this is not going to be a comprehensive discussion, but I'm going to at least give you the basics and give you some food for thought. So the 3 basic documents of estate planning are healthcare proxy, durable power of attorney, and last will and testament. We're going to talk about each of these documents in somewhat detail, but I just want to say now that the first 2 documents, healthcare proxy and durable power of attorney, are good while you're alive. The last document, the last will and testament, is effective after you have passed. And what's interesting today, for example, I met with clients, a husband and wife, and when they called me for a will. And I said, what about a healthcare proxy and power of attorney. And they asked me, what is that? So we had quite a long conversation today because they thought that the last will and testament would take care of all of their needs. But you'll soon find out, if you're not already aware, that each document has its own purpose and they do not overlap. While they complement each other, they each fit a particular role that cannot be imitated by another document. So let's start with the healthcare proxy. And I actually find this one of the most interesting documents because it applies to healthcare decisions. We're talking end-of-life decisions, surgery, medicine, the location, the hospital, the doctor, et cetera, only if you are unable to make your own decisions. So Michael today, who is our moderator, thank you, Michael. I may call you out a little bit. Michael today, thank God, knows who he is. He's able to understand what people say to him. We're not talking about a physical disability. We're talking in terms of a healthcare proxy and when it becomes dispositive, a mental disability. So not only can Michael, thank God, understand what is being said to him by a doctor or anyone else, he can also communicate what his wishes are. So if that's the case, no one, not his wife, not his doctor, no one else can make a decision for healthcare for him. From the age of 18, which is the age of majority in New York State, each person is considered under the HIPAA law, I'm sure you're familiar with that, to have a privacy right, a right in his or her own medical record. So for example, I have 4 adult children, over the age of 18. I cannot, without their permission, without a healthcare proxy, get access to any of their medical records. If I had a child under 18 as the natural guardian, I would have access. But once your child is 18, you can't find out anything about them unless they agree. We do have, each of us, that right of privacy. That also goes husbands, wives, etc. There is no exception. You have right to your own privacy. So anyway, if you cannot communicate and understand what's being said, and if you don't have this document, this legal document in place, then the doctor is going to make the decision. And most doctors are somewhat interventional. They don't want to be sued for medical malpractice. We live in a very litigious community and country. I don't practice that area of law, so I don't take it personally. But it's true that many doctors are sued, hospitals are sued, and they're afraid of not doing enough, whatever enough is. And as a result, they often overprescribe or do more than you might normally want. But if you have an agent, and we'll talk about who that is, if you have an agent who expresses your wishes, that agent can say, no, Michael would not want this procedure or that medication or whatever the case may be. And therefore, whatever the agent says will go. So that is, if you look at the last bullet point that I have there, that is probably the most important point of the entire proxy, although there are many important issues: selection of proxy agent and at least one successor. In fact, I like one at a time. I like an agent and one backup, a successor, and then an alternate. And why? Because sometimes you name an agent. Let's say I name Michael, and Michael either predeceases me, is unavailable, is unwilling, whatever the story is, as nice a guy as he is, he can't do it all. And so as a result, if it fails, meaning I've made my plan, I've named Michael as my agent, but for whatever reason, he cannot act, and I don't name a backup, it's useless. If the document needs to have a person, an agent, to make those decisions. Again, we're making important emotional decisions about end of life, as well as how you wish your life to be lived while you are alive. Only healthcare. There is a HIPAA release. As I said, it's very important for your agent to speak to doctors, and without that HIPAA release, no one over the age of 18 has to divulge any information or release that information. Here's another important issue in the healthcare proxy: do not resuscitate, commonly called DNR, or keep alive at all costs. And of course, there's something in between. Law and life are not black or white, right? It's gray. And so the point here is that your wishes, not Zahava's wishes or Michael's wishes or your wife's or husband's wishes, They're not important. Your wishes are the ones that are important. So it's very important for you to communicate what you want, and especially if you can't communicate and your agent has to understand or interpolate from the document what your wishes would be. Organ donation. So some people say, oh, I have that on my driver's license. Well, maybe your driver's license is not with the hospital, but the healthcare proxy is. And as a result, many of you know that if you're going to have organs harvested, there isn't a very long period of time, sometimes hours, if that, to harvest organs for transplantation. So this is a great place to put any kind of organ donation plan. Burial or cremation instructions. I have clients who have done pre-planning, which I'm a big fan of pre-planning, and I can talk about that. You go to a nursing home, a funeral home, excuse me, and through New York State, there is a certain partnership program whereby when you are calm and you are alive, you can plan basically what kind of funeral you want so that your family, after you die, your family who's grieving doesn't have to deal with the mourning, meaning, you know, the grieving over you, as well as, oh gosh, we have to spend $15,000 now, which is what some funerals cost. Also, I have a client, I'm now administering his estate. Unfortunately, he died of COVID recently. And in his healthcare proxy, he put specifically he wanted to be cremated and what he wanted with his ashes, the disposition, et cetera. And that was really important because when he was near the end of life, his healthcare agent had arranged nothing, he did not pre-plan, but it was in his healthcare proxy. He wanted to be cremated and the procedure and what, as I said, the disposition of the ashes. And as a result, the funeral home was able to plan everything so that when he died, that was one less thing that the family had to deal with. And that was only because his wishes were in his healthcare proxy. So that's important. I'm going to move on now. And here's some issues to consider. And I don't know if you have paper and pen handy. Obviously, we're not making legally binding healthcare proxies now, but these are some issues for you to consider. You don't have to, you know, raise your hand or answer here, but what would you do? Whom would you pick? What would your wishes be? So first, whom would you choose to be your healthcare agent, and who will agree to do so? Because not everyone would agree. And it's really important to speak with your proposed agent to say, Michael, you know, I want to explain to you what's involved. Would you agree to do this for me? Even though Michael's a great guy, maybe he's not up to the task, or maybe he'll say enthusiastically, yes, of course. I don't know, but it's important to ask and to get that answer. So here are some factors to consider. Proximity. Does that person live locally? So I met with someone today whose family, who comes from South Africa. This is just on my mind because I met with her today. Her family's from South Africa, and she's thinking of naming someone in South Africa as her agent. That's not a great choice. That person may be wonderful, but that person is way too far away. You really need someone closer, someone preferably in the New York area who can, if necessary, come to a hospital, come to a hospice, come to wherever you are to see, are you getting good care? Is the course of treatment appropriate? It should be someone who is fairly local. California also isn't great. I mean, if that's your only person, I understand, but try to find local people. Age and health of candidate. So, you know, with COVID and with life, we never know when our time will come, when we will pass or die, or when we will become ill. Hopefully we'll be healthy for a long time, but you never know. So if you choose someone who is, I'm going to say older, which is a relative word, older rather than younger, there's a greater chance that that person may predecease you, die before you. Also, what is the health of the candidate? Is the person healthy enough to be able to come and help and serve as your agent? Willingness to act, we already talked about that. Similar view of healthcare decision. Let's say you want to be kept alive at all costs. Or I'm going to take the reverse, actually. Let's say you want do not resuscitate. And the person you're thinking of as an agent may be, and I say this as a religious woman myself, it may be someone who believes that only God decides who, when our time comes. And as a result, maybe that person would not give a DNR order. Maybe that person believes you should be kept alive. So maybe that person is not the best agent for you, because no matter what I believe, if I'm an agent, I should follow the wishes of the principal, right? You being the principal, you're the person who makes the proxy. I'm just giving you ideas to think about, ability to handle difficult decisions. If you choose someone who is not, I don't want to say not mentally stable, but someone who cannot handle a lot of pressure, a lot of difficult decisions, that's not a good decision. You need someone strong. Oftentimes, if you have someone in the medical field, that might be a good option, because that person already understands procedures and how things work and the medical terminology, et cetera. But if you don't, it could be someone else. Please name a successor healthcare agent, right? Your backup, at least one. And if you can, two. And I don't like to do two people together, because then both have to be available, both have to agree. I mean, that's hard to do. So try to think of one at a time if you can. What are your end of life wishes? Keep alive at all costs, do not resuscitate, or something in between. And what would that look like for you? Do you want to donate organs, make an anatomical gift? Are there any limitations on that? Do you have the cemetery plot prepaid? Do you want to be cremated? Do you have pre-need funeral planning in place? All of this goes into the healthcare proxy, not into the last will and testament, which we'll get to later. And that's because the healthcare proxy is given to the hospital, the doctor. So at the moment of or toward the end of your life, plans can be made, decisions can be made. If you have to wait until a will is probated, and we'll talk about that, that could be months down the road. And finally, do you have specific instructions to provide to your agents? I currently have a client who is a minister, and she wants certain hymns said at her funeral. And she wants certain people to say them, and all kinds of instructions, which are lovely. And that is the place to put all of your instructions. So we spent a lot of time on healthcare proxy. We won't spend as much time on the other documents, but hopefully I've given you some food for thought. We're going to go on to the durable power of attorney now. So if the healthcare proxy deals with healthcare decisions, the durable power of attorney deals with everything else: financial matters, IRS, Social Security, selling your house, and accessing your bank accounts, all your pension, everything you have that is not related to healthcare decisions, billing, even healthcare bills, that goes to the power of attorney. One other thing I want to say, you notice it's called durable. That's because even if you make it today and you're fine mentally and you know who you are and what you want to do, even if later on, hopefully not, you develop dementia or you're in a coma or whatever the situation is, it's still good. The power of attorney is still good. So as I say, valid if you later become incapacitated in whatever way. Again, you want to choose your agent and successor agent wisely. So if with that healthcare proxy, you need someone who's emotionally stable and can deal with very difficult decisions, here the agent is dealing with kind of cold decisions, cold issues like money, taxes, Social Security. You need someone who can keep records, who can keep files, who can deal with an accountant, with a lawyer, who will pay bills on time. If you know who that is, that's your person. And you need some backups. Now, what's interesting about the power of attorney and different from the healthcare proxy is that this document must be accepted. The agent must accept. And that's because prior to 2010, which was the current law that's in place, and we'll talk about that in a moment. Prior to 2010, the agent did not have to sign. So if I name Michael as my agent, I don't tell him. It's kind of a secret, I guess. And I name him as my agent, and then all of a sudden, maybe I'm incapacitated, even though it's effective immediately. I don't have to be, but all of a sudden I'm incapacitated, and I need Michael. We need Michael to do things. And Michael says, wait a minute, Zahava never asked me. I never agreed. And he's not going to act. Then that power of attorney is useless. So it's really important, and actually now the law, that the agent must sign, must agree saying, yes, I agree to be Zahava's agent. The power of attorney law was just revised by Governor Cuomo in December. It goes into effect in June. There are some changes, some of which are very important, including there is no more gift writer that is involved due to security issues. That's beyond the scope of this discussion. But what's important is if you have a current power of attorney done by an attorney licensed in New York State, then you may need to provide to the bank or to whatever financial institution that POA is being presented, an opinion letter from the attorney. But if you have a really old power of attorney, I'm not sure if it's good. You should take it to your financial institution and say, ask the back office, would you accept this? Because if they say, no, it's too old and we're not going to use it, then you need to make a new one. Just letting you know. Okay, now we're up to the last will and testament. And the healthcare proxy and power of attorney, if you recall, I said are good while you're alive. This is the one document that only becomes effective after you die. So why is it called a last will and testament? Because you can make a will today, tomorrow, the next day. They're all valid, presumably, right? They were all done properly according to the estates, powers, and trust law. However, it's the last one that will be effective. The last one that the surrogates court, which is the court of sole jurisdiction over deceased persons in New York State, that's the only will that the court will entertain. So here we don't have agents. We have the person is called an executor. If you're from Florida, you know people in Florida there, they call that person or that role a personal representative. But here in New York State, we call that person who marshals all the assets and then distributes according to the law, the will and the law, the executor. And you need at least really one backup in case something happens. There are all kinds of what we call bequests, meaning whom do you want to inherit from you? Specific, like I have a ring, I want to give it to Michael. General, money. Charitable, I really like Channel 21, WLIW. I want to give them and see my money continue to help the community. Or residuary, everything that's left. And there are many other categories. You have to be at least 18 years of age. 2 disinterested witnesses need to witness your signing of the will. That means not your spouse, not anyone mentioned in the will, not anyone really related to you by blood. There are a lot of conditions there. It's got to be in front of a notary as well. If you have young children, meaning minor children under the age of 18, it's a good idea to indicate whom you would like to be the guardian of your child, the legal guardian, if something happens to you and you die before they reach the age of majority. The reason it's a good idea to mention this and even to write a whole paragraph about it, why? This person shares my religious beliefs. This person, my children love this person. This person lives in our community. Whatever the issues are, the reasons are, it's a good thing to tell the surrogate, who is the judge, because that surrogate, that judge has the decision-making ability to say either yes or no. Just because you name Michael as your agent doesn't mean the surrogate is going to agree. So you want to think of who would be best to be appointed as your children's guardian, and also why. And we're going to talk about trust in a minute, but I just want to throw this in here because if you set up a trust, often called a pour-over trust or any kind of trust, there is a difference between a trust that goes through the will and an inter vivos trust, which is a trust while you're alive. And many of you are familiar with those, I'm sure, either revocable, it can be revoked, you can take it back at any time, or irrevocable, you can't. Okay, some miscellaneous matters that if you walk away with nothing else tonight, but you learn from these and implement them, it'll be a successful night and time well worthwhile for you. First, do you have a bank safe deposit box? If you do, that is not good, and it's better to have a fire safe box in your home. Why, you may ask? Because even if, especially if you're the only person on the safe deposit box, but even if you're, let's say, married and your spouse is also on the box, when one person on the box dies, the bank closes the box and you have to have a separate either a separate proceeding in the surrogate's court, which is expensive, to open just to open the safe deposit box, or you have to wait many months until the will is probated, meaning offered and accepted by the court. So fire safe box is the way to go. Sometimes people say to me, well, I have very nice jewelry, so I don't want to put it in a fire safe box in my home. Again, this is not for theft issues. This is just for access and fire safety. I understand about the jewelry, and then you'll wait, or actually you'll have passed, but your family will wait to get the jewelry until many months later. But if that's okay and you rather keep it there, that's fine. But at least your will and your other documents really should be in your house. I am a strong proponent. Oh, wow, time's flying. I am a strong proponent of long-term care insurance. I myself got it when I was 38 because I saw people around me who needed it and couldn't get it anymore. So when you need it, it's too late, right? You have to be healthy in order to qualify. And I want to explain something. And we're going to talk a little bit about Medicaid, but not too much. Most people aren't sure, and I don't know if this applies to the group here, the difference between Medicare and Medicaid. So here we go. Medicare is a government sponsored program, which is age-based. If you're 65 years old, Medicare, if you're 65 years old and you're poor or you're extremely wealthy, you qualify for Medicare. Great program, right? For senior citizens, great program. Medicaid, AID, on the other hand, is financially based. So you could be 1 hour old, 1 day old, or 100 years old and be poor and qualify for Medicaid. It's not age-based, it is financially based. Medicare, which is the age-based, does not pay for any long-term facility. It doesn't pay for nursing home. It doesn't pay for assisted living. You're on your own for that. I'll say that again. With Medicare, the government does not pay for your care if you need assisted living care or nursing home care. Medicaid, which is financially based, if you are poor, literally poor, and the discussion is beyond what we can do in this program. Medicaid does pay for care. I don't know if you will like that care. You have a limited number of facilities which offer that care. And that's why long-term care insurance, which is private insurance, is a fabulous option. And I strongly recommend it. So that's all I'll say about that for now. Life insurance. I am a big fan of term life insurance. Term life insurance. If you have dependents who rely upon you, whether a spouse, a child, parents, if God forbid something happened to you and you died, how would those people survive? Do they need money for college? Do they need money to pay off the mortgage? Term life insurance is the answer. It's relatively inexpensive. It's a great option. Disability insurance. What happens if you can't work anymore? If you work now and all of a sudden your income is gone, how are the bills going to be paid? Something to consider. I don't really want to talk about Medicaid planning right now. I will, however, say some of you may have heard of a 5-year look back period. Medicaid is specifically in New York, but everywhere else, Medicaid needs money and the government is spending a lot of money. Medicaid is state-based and even county-based. So if you live in Nassau County is the one who administers Medicaid. And they're very careful. They want to make sure that people are not purposely fraudulently transferring money to family so that it looks like they're poor when really they're not, because the rest of us taxpayers, we're the ones paying for Medicaid. Just something to think about. Gifting. I can give Michael, his wife, every one of his children up to $15,000 every year. I don't have to file a tax return, a gift tax return. I don't have to pay tax. Michael doesn't have to pay tax. It's not income to him. It's a good way, especially if you are financially solvent and let's say you're a grandparent. You don't have to be a grandparent, you could be a parent. But you're a grandparent, you want to see your children or your grandchildren or other family or friends enjoy the money. Maybe they need the money. You could see them use it during your lifetime. Very important. I met with clients today who on all of their accounts, life insurance policies, everything they have, there were no or limited beneficiary designations. Beneficiary designations on an account mean that if I die, my husband, who, if he is my designated beneficiary, he doesn't have to be, but if he is, he takes my death certificate and his ID and goes to the bank and he gets all the money. That's how it works. So there's no probate. I mean, you still have to probate other things like a house and other assets, but with accounts or insurance policies, et cetera, where you can name a primary beneficiary or beneficiaries, plural, and contingent backup if something happens to that primary level, you really should. It's great. It's just an easy way to get money. I also do pre and post nuptial agreements, even though I'm not a matrimonial lawyer, but a lot of estate planning goes into this. If you marry the first time and you name, let's say I name my husband as my beneficiary, or I name whatever I do. When I divorce and then remarry, if I don't change my designation, if I don't make a prenuptial agreement with before I marry my second husband, my first husband might get everything, or my children from that first marriage may not get anything. I know I'm throwing out teasers here, but it's really important, especially when if second marriages and beyond, or even I've seen on first marriages where one spouse is very well off and the other is not, they haven't gotten married yet. And what happens if we get divorced? I don't necessarily want you taking half of my money. And that's what happens in New York State, generally speaking, with marital assets and deed transfers. A lot of people come to me, oh, I want to transfer my property to my adult daughter so that it's easier. Well, you could do that, but then you lose certain tax benefits called a step up in basis. So be careful of that. All right, I'm moving on. I'm going to just briefly talk about a trust. What is a trust? So a trust isn't a thing. You can't see it. It is it's based on a document, but if you think of it as an entity, which is empty, and in order for the trust to have any value, you have to transfer assets into the trust. It's like depositing, but there are all kinds of means of doing so. There are reasons to have a trust. We kind of talked about inter vivos during your lifetime or testamentary. I want to talk about the reasons. So basically the reasons to have a trust, and no, not everyone needs a trust, not even no matter what anyone else says. It's all about the control. That's really what it's about. If someone is on, let's say a beneficiary or proposed beneficiary is on governmental assistance, meaning whether Medicaid, SSI, whatever the case may be, that person upon receiving a gift or an inheritance may be thrown off the rolls. That could be the worst thing for that person. You may not think that way, but think of it this way. That person's now not going to get assistance and be kept off for a long time, and it negatively affects their service. Medicaid planning, we've sort of talked about. Spendthrift. I don't know if you remember, Imelda Marcos years ago had, from the Philippines, had many shoes. If you know someone, let's say one of your beneficiaries is going to go out and spend every penny in his or her pocket, you don't want to give them anything outright. Outright means I'm going to give to Michael right now money, and he can do with it as he wishes. But if Michael likes to, I don't know, gamble or, addiction, or maybe maybe he takes drugs, whatever the case may be, maybe that's not a good idea for him or for a way to maintain his money. And ease of administration. For people, especially who either have family members who can't handle things too much, or they just want to make things easier, that's another reason. But a trust is not for everyone, and it's a little expensive to set up, but if you need it, it's a wonderful vehicle for implementing your estate plans. The trustee, just like all the other documents we talked about, you need to trust your trustee and successor trustee wisely. What does a trustee do? The trustee holds all that money and property and basically has, I don't want to say carte blanche, but has a lot of control over what happens to that property. May you be the grantor, that's the person who sets up the trust, creates the trust, the trustee, the person who manages the trust, and the beneficiary. Absolutely. That's in a revocable trust or revocable trust. You control it. It's part of your estate. And I just want to say, I did not include in here before I move on, estate taxes. Estate taxes right now, the threshold, meaning the amount over which you have to pay an estate tax is pretty high. In New York State, it's about $6 million. So if you die with less than $6 million in assets, your estate probably will not need to pay estate tax. On a federal level, it's about 11.4 million. But in the trust and estates bar, we're pretty sure that number is going to come well down. President Biden has filed a proposal for that, and really it should come down. The government needs more money, and those thresholds are very high. So there are very wealthy people who are not paying a portion, relatively speaking, of what is necessary. So expect those numbers, those estate thresholds to come down. I'm almost done. 2 quotations by Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. And by failing to prepare, you are preparing to fail. And I share this with you because somewhat recently, I had a husband and wife come to me, and the wife was gung-ho, we're going to do the estate plans. Everything will be, what a relief it'll be. And the husband said, nah, I don't think so. And when I talked with him about it, he said, I don't know, if I make my estate plan, maybe that means like I have to deal with death, and I have to deal with the reality that we all don't live forever. And I said to him, you know what, whether you deal with it or not, the day will come, I hope many years from now, but the day will come when you die. And it's really up to you to decide if you're going to make it easy, if you're going to bless the people you leave behind, make things good for them, or if you're going to make it harder, more expensive, more cumbersome, and longer to deal with. It's really up to you, because either way, you're the one in control. And that's it. If you want to contact me, feel free. There's my email address, my phone number. I hope everyone is well, staying safe, getting your vaccines. And my office is in, oh, and I didn't put Westbury there, sorry. My office is in Westbury. There are my phone numbers and all my contact information. And let's see, I see there's one. Will replay be available? No, Bruce, I'm sorry. Replay will not, although I am recording this for YouTube, and I do have a YouTube channel. You could look up Zahava Schechter on YouTube, and hopefully by tomorrow, the next day, it will be up and you can see my other YouTube videos. I also have a YouTube video on real estate and other things that I do. So that's what I have, and I've stopped my share. If anyone has questions, I'm happy to answer.
At this point, I think if anybody has a question, you should be able to just unmute yourself and
Yes.
speak up.
Absolutely. And if not, we'll say good night. So it's now or never. Yes.
Hi, I have a question.
Hi, Tony.
Hi. Regarding the healthcare proxy, so does your agent and the backup get